Craig Bell, you have pled guilty to being concerned in the supplying of cocaine and diamorphine, both of which are Class A controlled drugs under the Misuse of Drugs Act 1971. From a search of your person, from within your car, and from a sports pavilion rented by you at Zetland Park in Grangemouth, police officers recovered cocaine weighing in total 746 grams and diamorphine with a total weight of 129 grams. In each case, the drugs recovered were of high purity. In addition, police officers recovered from your possession scales, knives, bags with traces of controlled drugs, and large quantities of adulterants. The total street value of the drugs recovered, assuming a level of adulteration prior to sale, is agreed to be approximately £270,000. All of these demonstrates to me that you were involved in a significant operation for the supplying of Class A drugs. I accept that you were not the directing mind of this drug supply operation. Rather, you were a link in the drug supply chain, albeit an important one. I have taken account of everything set out in the Criminal Justice Social Work Report, and also what has been said on your behalf today by your legal representative. In particular, I take fully into account what has been said about your personal, family, and employment backgrounds, and about the circumstances in which you came to be involved in the activities which bring you before this court today. You have a very limited record of previous convictions in 2000 and 2001 for relatively minor offences of dishonesty and disorder. Those offences were all committed when you were a teenager. You have no previous convictions for offending involving drugs. For the purpose of sentencing today, I proceed on the basis that you are, for all practical purposes, a first offender. You will appreciate nonetheless that the gravity of the charges to which you have pled guilty and the quantity of Class A drugs involved leave me with no alternative but to impose a substantial sentence of imprisonment. This court has repeatedly stressed the misery caused by operations which supply Class A drugs in these quantities. Those operations would not be able to function effectively without the involvement of those who assist them, as you did. Had you been convicted after trial, I would have imposed a cumulative sentence on charges 1 and 2 of 6 years imprisonment. In view of your pleas to those charges and the timing of those pleas, I shall restrict that sentence by 1/3 to a period of imprisonment of 4 years. Since you have been on bail since your first appearance on petition on 3rd of June last year, that sentence will run from today. You have pled guilty to causing the death of Carol Georges and serious injury to Nicholas Georges by dangerous driving at a roundabout in East Kilbride on the 3rd of November last year. You drove while unfit after having consumed drugs, at an excessive speed and without keeping a proper lookout, failed to slow down on your approach to the roundabout, mounted a traffic island and drove straight onto the roundabout and collided with the car driven by Mr. Georges, as a result of which he was seriously injured and Mrs. Georges was killed. Mr. Georges and the close family of Mrs. Georges have been devastated by the death of Mrs. Georges. Their victim statements make for heart-rending reading. You are now 39 years old. You have previous convictions, including 2 convictions in the High Court, and at the time of this incident you were on licence and subject to the extension period of an extended sentence, which was due to expire on the 16th of December 2023. You were convicted in February 2007 of driving while unfit through drink and/or drugs, and disqualified from driving for 2 years. In January 2010, you were sentenced to 9 years imprisonment for assault with intent to rob, assault to severe injury and permanent disfigurement, and assault and robbery with an extension period of 5 years. And in January 2019, you were convicted of careless driving. It can properly be said that you are a criminal. In sentencing you, I must first deal with the unexpired portion of the sentence imposed on you in the High Court in January 2010. As at today's date, there remain to be served 1,299 days of that sentence. I shall order that you be returned to prison for a period of 3 years and 6 months, to be served before and to be followed by the sentence of imprisonment about to be imposed for the offence on this indictment. Secondly, I must impose sentence for the offence of this indictment. Having regard to your criminal history and the circumstances of this offence, had you been convicted by a jury after trial, I would have imposed a sentence of 8 years imprisonment. In light of your plea of guilty, that sentence will be discounted to 6 years imprisonment. Thirdly, I must deal with the issue of disqualification from driving. You are disqualified from driving for a period of 10 years and until you pass the extended test of a competence to drive. Behrouz Hamedi. On 9th of March 2020 at Aberdeen High Court, you were convicted of a single charge libelling the abduction and rape on 1st of November 2018 of a young woman who had become separated from her friends on a night out in Aberdeen city centre and who was unknown to you and was at the time highly vulnerable due to her intoxication through alcohol. You locked her in your takeaway food shop, having closed the premises and sent your assistant away for the night, and thereafter proceeded to perpetrate a sustained sexual attack upon her, all as libelled. Police officers who attended looking for your victim found the premises in darkness and were unsuccessful in their attempt to force open the door. Your defence of consent was plainly rejected by the jury. This was, in fact, in my view, an opportunistic sexual crime with a predatory component. The gravity of this offence means that the only sentence which can be appropriately imposed on you today will require to be a substantial custodial one. You are 60 years of age and are in terms a first offender in that you have one minor summary non-analogous conviction. You have a very supportive family and a strong and stable employment history. It would appear that this offence is wholly out of character for you. Nevertheless, in your discussions with the author of the Criminal Justice Social Work Report prepared in respect of you for this sentencing hearing, you appear to have minimized your criminal conduct and accepted little or no responsibility for that. The author of the report has indeed assessed you as presenting a risk of serious harm, albeit it has concluded that there are no known public protection issues in respect of you. I have listened carefully to the helpful submissions advanced by your counsel this morning and propose to take all the points that have been advanced on your behalf into account in determining the matter of disposal. I note in particular all that your counsel has said concerning your family circumstances, your work history, and the loss of your business, your health, and indeed your whole personal circumstances. I have, in addition, read with care the letters from yourself and your brother, which were earlier submitted to the court on your behalf, together with a psychological report recently prepared in respect of you by Professor Macpherson. Turning to disposal, I have decided in the whole circumstances that in the light of all the material before me, that an extended sentence is not merited in your case, and that a significant determinate sentence with the usual license provisions will provide adequate protection to the public in respect of the level of risk presented by you. On this indictment, therefore, you will serve a sentence of imprisonment of 6 years' duration, backdated to the date of your conviction and initial remand in custody, namely the 9th of March 2020. Finally, as a result of this disposal, you will now be subject to the notification requirements of the Sexual Offences Act 2003 for an indefinite period.